Good afternoon, everybody. I really tried to make a coup d'etat from this chair because I tried to impose my decision and my will, trying to use one of the official languages of the EU, the Italian, but my speakers refused. So I had a kick in the eye to my authority. So, first speaker should be Professor Oleg Volgin from Moscow, and he's not here. And I tried to summarize his papers and his ideas. I'm really sorry because he's not here, because I disagree in every part of his paper with him. But you know, he's Russian. Sorry? I don't know. Maybe he was held by someone in Russia. I said, why? Because Professor Volgin from Russia tried to explain to us as Europeans how EU should work. You know, it's quite different. It's quite difficult to teach us how it work, how EU could work, because EU sometimes didn't work at all. But anyway, I don't want to speak about his bad conscience about the Europe, because he spoke about how to strengthen Europe. How can you imagine a Russian could hope that Europe could be had more strength than Russia or other actors in Europe? And he's on. He tried to, let me check his ideas, starting from the ideas of Anthony Giddens in his book Turbulent and Mighty Continent, where Professor Giddens wrote about the Europe of bureaucrats, and I like it, and Europe of the effective leadership. Professor Volgin spoke about the power of the administrative institutions and the power of political leaders, and above all, the power of the supranational democracy. It means the power of the European peoples. A Russian who speaks about the power of the peoples. You know, it's quite difficult to accept these ideas, even if we can think about where Professor Volgin works, foreign ministers. That's it. So, let's go on, and we start with Professor Fabio Masini from Roma 3. And he's going to speak about imaging multi-level democratic economic governance. You have the floor, and 10 minutes.
Thank you very much, Mr. Chairperson. Actually, the title is a bit different, as you can see. I changed a little bit, which is also a bit cryptical, reconciling Demos and Kratos, the economics of a global multi-layer democracy. Well, what is it about? It's about how economics can contribute to this dialogue on supranational democracy. And, well, as you probably know, there is a popular view in economics about the relationship between economics, especially global economics, integration, globalization, and so on, and democracy. It's Danny Roderick 2011 book on the globalization paradox, where he states that there is a sort of trilemma between democracy, national determination, and economic globalization. And in his case, of course, the solution lies in giving up economic integration. Of course, if you think about his claim, democracies have the right to protect their social arrangements, and when this clashes with the requirements of the global economy, it is the latter that should give way. Of course, if you see it like that, you should actually put aside economic integration and privilege determination, self-determination, and democracy. My claim is that it's a bit radical in this speech, but I think that in this kind of conference we can be as radical as we want, because it's a sort of visionary dialogue and conference, so no problem. So I feel free to provide a suggestion, which is that Danny Roderick made a complete mistake, completely at all, because democracy is not what he means. Self-determination doesn't exist, and actually economic globalization and integration are very different things. I'm not able to go into the details of this all now. That the key point that I want to stress is that first of all, democracy is not a coherent idea, but it's divided into two different concepts, which are demos and kratos. Democratia. Demos is the needs of citizens, collective needs of citizens that need to be satisfied by their governors. And kratos is the exercise of power, which usually is destined to satisfy the needs of the demos. Usually, but not always. And what we are witnessing nowadays, in Italy for example, for sure, but in Europe in general, is that there is an increasing gap between demos and kratos, between the collective needs of citizens to be satisfied and the capacity and the ability and the will even of the governors to satisfy the needs of their citizens. So kratos and demos are parting away, are diverging. So this creates some problems about the concept of democracy, first of all. The second point is that self-determination is just at least a slippery idea. It's something, it's sort of myth. What is self-determination? To which group you can allow to self-determine themselves? Is it the Spanish government, the Spanish people, or is it the Catalonia people, or is it the Girona people within Catalonia? Who is allowed to self-determine? And what happens if these self-determinations are different? So, just to understand at what I'm aiming. So, the true question is not how democracy can be compatible with economic integration and self-determination, but the problem is how to make democracy compatible with integration at each and every level of the aggregation of society. And now I explain myself a little bit better. So the first question to me was, when Susanne asked me to contribute to this dialogue, can I say something as an economist on this? Well, actually, there are many things that have been said in the past from economists on this issue. There are at least three different visions, let's say, about the compatibility between democracy and economics, and they are very much different from one another, and they also are a bit, let's say, not precise on the concept of both democracy and integration. But anyway, the first one is functional overlapping competing jurisdictions, which is a famous book and paper first of Frey and Eichenberger from 1999, and then a book of some years later, but it dates back to Thibault, to the debates on polycentrism and competitive federalism in the 50s in the United States, soon after the war. The second point is the second strand, let's say, vision, intellectual influence, is national politics is a problem to integration. So it should give away this the power of making the rules of the market and of governing the economics through the delegation to certain apolitical technical bodies or to informal bodies. This is Ostrom. You are probably familiar, I don't know, with Ostrom. She was a Nobel laureate. So we have here Hayek, Buchanan, Tallock, and again Ostrom. So most of them are Nobel laureates, so they should be quite known. And then we have hierarchical federalism, which dates back to the early 20th century. Luigi Einaudi, Lionel Robbins, Robert Musgrave, Olson, Triffin, Padoa-Schioppa, and many others. Which thinks that there should be concentric layers from local to global each of them represented politically. Apart from these three strengths, where can we start if we think in terms of supranational democracy from an economic point of view? Well, the basic point, I think, is that that we should give away, should trash, let's say, the idea of public goods. There is no public goods. There are collective goods. Public goods are referred to the national constituency. But actually, people do not need public goods in terms of national only. They need collective goods. They share needs with other people. You have here some examples taken from my personal experience. I live in Florence. So the management of public transport in Florence is something which I share. The need of an efficient public transport in Florence is something that I share with people living in Florence. This means that I need a place, an institution, where there should be a collective decision making which is enforceable, because otherwise there's no collective identity. You understand my point? So, and this can be brought up to the global level. Of course, the management of the water of Arno. Arno is the river in Florence. It's not only a matter of the people living in Florence, but it's a matter of people living in a whole basin, hydric basin of the Arno. So it requires a greater constituency, a greater place where decision making can be made and enforced again. And so we can go on from the regional, from the local, from the regional level, to the national level, to the continental level, regional in terms of continental level, European Union, for example, but also, I don't know, ASEAN or Latin America, and then global public goods, which represent humankind. All these levels should have, because they have people who share some needs, should have institutions where collective choices can be made and enforced. Of course, in all this idea, the European experiment is crucial. Because the European experiment, what we started 70 years ago after the Second World War, which is to share sovereignty, is exactly crucial to make, to show to the world, to the world, let's say to the humankind, that it is possible to fragment and reconstruct sovereignty on different layers, from the local to the global. As you know, the European experiment is now under attack, is now under strong critics. Is it because it failed? My claim here is that it is because it didn't arrive where it should be arriving, where it was supposed to arrive. We left the bank of the river where we had national sovereignties, and we started 70 years ago to go through the river until we saw the other bank with shared sovereignty. The problem is that we had several crises in the meanwhile, and especially the last crisis, the sovereign debt crisis, because of the governing structure of the euro area, but I'm not entering into this now. Anyway, the crisis let the level of water come up and more up to the throats of people. And when people have the water at your neck and at your throat, of course you look back from where you come from to where you come from. Because of course you know that it's not an efficient system, but you also know that it's a safe, apparently safe. You know where you come from. If you don't know how much it takes to go to the other bank and what exactly is on the other bank, because we actually don't know yet. Nobody told us exactly we want to arrive there. We want to be a federation. We want to share sovereignty on several competencies, and we want to have a multi-layered democracy. We don't know it yet because nobody told us. Of course, I understand people nationalistic feelings, because nationalistic feelings are exactly the reaction to this kind of increasing level of the water in the river. So we cannot go on like that. We have to know when we arrive on the other bank and what we find on the other bank. It's a very dangerous situation in my idea. The last point that I want to touch, because there's no time, is this. If we want to have a multi-layered democracy, we need constitutions. We cannot rely on governance. because governance is hardly enforceable. So we need some kind of constitutions, some kind of. Of course, we know national constitutions, which are very strong, which are omnicomprehensive. Everything is put in the constitution. We don't need this. We need a multi-layered constitution. In Europe, for example, I think that we need a new constitutional pact. Call it however you want, a fundamental law or whatever. You don't like constitution, fundamental law, I don't know, I don't care. The idea is that you have competencies that are to be allotted to the local level, some to the regional level, some others to the national, some others to the continental level. Migration, energy, higher education, big infrastructures, defense and security policies, and so on and so forth. Maybe not too many, maybe it's enough, but they go at the heart of the exercise of sovereignty. And this is the reason why there is a detachment between the exercise of power and the exercise of sovereignty. And the other point is that constitutions are the only way, effective way, that you can enforce decision making. Because if you don't have constitutions, there's no enforcement. This is the big difference between government and governance. The government has an enforcement let's say, capacity. Governance has no effective enforcement capacity. Where do we go at the global level? Or where should we go at the global level? I mean, constitutions, at what level? At what level? What is the optimal level of constitutions? This, of course, is country-specific, region-specific. It depends on many things, and probably it's a bit too early in the history of humankind to speak about constitutions at the global level. Probably at the continental level, in Europe, for example, we are in a way mature, or we might be mature for some kind of supranational constitution, which of course we are not, for example, in the Latin America or in Asian, where the national monopoly is still, of power is still greater, let's say, than in the case of Europe, where interdependencies are so strong that it's really very difficult to exercise sovereignty if not sharing sovereignty. Conclusions, it's not conclusions, I mean, it's just idea. So the first point is that democracy is not possible at the national level. It's impossible at the national level. It's possible only if you have different layers, constitutional layers, where collective decision making is possible and enforced. So it's possible only in a multi-level, multi-layer system. What does it mean in economic terms? Basically, okay, it means several things, and we have to choose between the three different lines of thought that I made at the beginning and which are very different. But basically, it means that we have to abandon the idea of the monopoly in the provision of public goods, at whatever level it is. Catalonia, no. Spain, no. Europe, no, because there are many public goods, collective goods, and each of them should be provided and decided on by different constituencies. This means that only a constitutional device can organize such layers in an effective way. Of course, the European experiment is crucial, because if the European experiment is destined to fail, it is probable that it is very likely that the whole structure of supranational, global supranational democracy might fail, because I mean this is the most advanced experiment of sharing sovereignty. Maybe we might start from a very simple idea, which is we have to choose. In one of the previous slides, I made the point that European integration has moved according to an idea: crisis, leadership, initiative. If you don't have crisis, I mean, each step forward in European integration depends on the existence of a crisis, of an initiative, a specific initiative, and on a leadership. We had several crises, we had some initiatives, and we don't have much leadership, although now we have Macron and Merkel. They're trying to, again, take up the leadership. I think we should need something similar at the global level. We have some crises. climate change, peace, I don't know. You can choose the one that you want. You have to find a specific, very specific and small initiative, and you have to find a leader which brings up the problem and starts to ask for resources and ask to the people to regulate the problem. Thanks a lot.
Thank you so much, Professor Massini. Two things very important that I'd like to underline, and I hope to have time to discuss on. The duality between public and collective goods that are so important, and the other one is where we didn't arrive, and we didn't arrive not just as a European institution, according to my opinion, but we didn't arrive as Europeans sometimes. So thank you so much. Two speakers now. So we have Diletta De Cicco, legal consultant at Meyer Brown in Brussels, and Mario Pagano is a PhD candidate at the European University Institute. So you got the floor.
Does it work? Okay, can you hear me? Thank you very much. Thank you for having us. Thank you also to Professor Susanna Cafaro for organizing this, such a great initiative. So we are very pleased to be here also because we are both from Apulia. So for us it's such a special meaning. We're going to talk about public interest litigation, which is very much related to what Professor Mazzini just said, the presence of collective goods and how, in this case, civil society organizations should be allowed to enforce these collective goods. Before getting into EU legislation, I would like to draw your attention on international environmental law, in particular on the Aarhus Convention. For those who are not very familiar with international or EU law, the Aarhus Convention is probably one of the most important pieces of international legislation regarding environmental democracy, since we are at the Supranational Democracy Dialogue, environmental democracy rights. In particular, it enshrines three main pillars, three main rights, individual rights. The first one, access to environmental information. The second one, public participation, the right to intervene, to participate in the environmental decision making. And the third one, the one we're going to talk about today, the right to access to justice in environmental matters. Access to justice before the EU Court of Justice, before the EU judiciary, is based on a very relevant provision of the Treaty of the Function of the European Union, which is Article 263. That actually, this provision sets the requirements for access to justice for individuals and legal persons before the Court of Justice. And this requirement is a direct and individual concern. A direct individual concern. This is very important, and I would like to clarify this, especially for those who are not familiar with law. To those who don't have a legal background. This requirement has been interpreted by the Court of Justice in a very famous case in 1963, so a long time ago, but this case law is still good law, is still there in the EU legal order, and this case law is the Plowman test. What does it mean, individual concern in particular? I will try to summarize. In other words, a EU measure must affect an individual for certain characteristics, for certain attributes which are peculiar to that person, in particular to that person, that distinguish that person from all the other members of society. So if you think about the environmental domain, the environmental measures usually are not individually identifiable measures. Usually environmental measures are measures with a very broad scope, with a general scope. So you can imagine how hard it is to enforce specific environmental rights in the environmental domain when a EU measure must fulfill this requirement in order to be challenged. The first time the Plowman test was applied in the environmental domain is the Greenpeace case. Greenpeace, the very famous environmental NGO, in 1996 tried to challenge an EU measure, a European Commission decision granting funding to the construction of two power plants in the Canary Islands. And the Court of Justice denied locus standi, denied standing to Greenpeace because that decision, of course, could not affect specifically, individually, the rights of Greenpeace. So the court stated that those rights are, however, fully protected by national courts, and so it actually referred to the preliminary ruling procedure under which national courts could refer a question to the Court of Justice for a uniform interpretation of EU law. The same reasoning has been applied over and over throughout the history of EU law in many other cases, in WWF, in European Environmental Bureau, in Diego Queré, and no one case brought by civil society organizations has ever been admitted by the Court of Justice. In this case, Unión de Pequeños Agricultores, UPA, Advocate General Jacobs proposed an alternative interpretation, an alternative way of looking at this provision. And he said, probably we should look at the individual concern by saying that a person should be regarded as individually concerned wherever a measure has or is liable to have a substantial adverse effect on his interest. So it is very inclusive, a much more inclusive definition of the individual concern. But unfortunately, in our opinion, of course, this interpretation was not ultimately followed by the Court of Justice, which confirmed the Plowman case. However, this whole case law was brought in 2008 by an NGO very famous in Brussels called Client Earth, and this is probably the reason why we're still talking about this today. Brought the entire EU as a whole, the European Union as a global actor, before the Aarhus Convention Compliance Committee, so the compliance committee of established by the international piece of legislation I mentioned in the beginning of our presentation, for in compliance of EU law with the Aarhus Convention. And on last year, so basically yesterday, the Aarhus Convention Compliance Committee released its findings and found that the European Union, was not in compliance with the Aarhus Convention, and many scholars reacted like this. Of course, so you can imagine how difficult it is to, or even from a legitimacy point of view, to understand the relationship between the responsibility, the liability of the EU in front of an international body is enshrined under an international convention. Regarding access to justice before national courts, I would like to talk about very briefly the Slovak Bear case. The Slovak Bear was issued in 2011, and in this case, I'm not going to go into detail in the explanation. I will just try to summarize the main findings of the court. The Slovak NGO wanted to intervene, wanted to participate in the environmental decision making in Slovakia, but the national authority, the Ministry of the Environment in particular of Slovakia, denied such a right, this right to participate. The Court of Justice, which was called upon on a preliminary reference to issue its ruling, denied direct effect of Article 9 of the Aarhus Convention. So the NGO could not rely directly on a provision of international law before the EU Court of Justice, and in addition, it applied the principles of equivalence and effectiveness, as stated that it is for the national court. So as we can say now, this is very important, the approach of the Court of Justice is totally different as far as access to justice at the EU level is at stake, and access to justice at national level is at stake. When we talk about access to justice before its own jurisdiction, the Court of Justice says, no, very narrow interpretation of the individual concern requirement. When we talk about access to justice before national courts, the court says, no, national courts must broaden access to justice, must grant the broadest access to justice possible, and interpret national law in a way which is consistent to the fullest extent possible with the objectives laid down in the Aarhus Convention. So a very different approach that, as we will see now, it will also be repeated in another very important public interest domain, that is data protection. So I leave the floor to my colleague Diletta.
So, as Mario said, the same approach developed by the Court of Justice in cases related to environmental matters was also applied in cases related to the right to privacy and the right to data protection. I took just two cases as a matter of example that were brought by the same NGO, one before the Court of Justice and the other one before a national court. And these cases really demonstrate how the outcome of a case can really be different if NGOs try to access the court at national or EU level. The NGO is Digital Rights Ireland, one of the most active and famous NGO in the field of privacy. The first case was brought by Digital Rights Ireland before the Commission against the Privacy Shield decision. I don't know if you are familiar with the Privacy Shield decision. This is the successor of the famous Safe Harbor. The Privacy Shield is a decision adopted by the EU Commission that allows transfer of your personal data, so transfer of EU citizens' personal data to the US, because the Commission considered that the US ensure an adequate level of protection of our personal data. Digital Rights Ireland, of course, disagreed because they consider that US provision, the US jurisdiction is not adequate. It doesn't ensure enough safeguards for our personal data when they leave the European Union. They tried to bring a case before the Court of Justice. This decision was quite awaited because it could have been a great opportunity for the Court of Justice to reconsider its approach to the Plowman test and allow an NGOs to represent the privacy right before the court. But this didn't happen, and again the Court of Justice considered that Digital Rights Ireland didn't have the right to represent its members and supporters and the public interest before an EU court. This case, it's Digital Rights Ireland case. So the second case I chose, as I said, was brought by the same NGO before the Irish court. The case was against the Data Retention Directive. This was a directive that allowed member states to introduce provisions for communication that applied to communication service providers. These provisions allowed communication service providers to keep our personal data for a period between 4 and 24 months for reason of detection and investigation. So really the direction was trying to strike a balance between defending the security, national security, and the right to privacy and data protection. Digital Rights Ireland brought the case before the Irish court that then referred the case to the Court of Justice because Digital Rights Ireland considered that the Data Retention Directive was disproportionate in affecting the right to privacy and data protection of EU citizens. And as I said, this time the Court of Justice ruled that the Data Retention Directive was invalid. And this was actually thanks to an NGO being able to defend the right to privacy and data protection at EU level, before the national court and then at EU level. The General Data Protection Regulation is a new legislation that will enter in force in less than 1 month, on 25th May 2018. Why I talk about it? It's because it will have an impact on the right of NGOs to defend privacy rights before national courts. The General Data Protection Regulation is quite famous at the moment because it introduces new requirements for companies that process personal data, but also because it strengthens the right to privacy in the European Union. The main article of the GDPR that interests our discussion is Article 80, that now allows NGOs to bring cases and lodge a complaint on behalf of individuals. Individuals have now the right to mandate an NGOs that can bring cases on their behalf. But there is still another possibility. Member states have the option to legislate under the regulation and introduce even the possibility for NGOs to independently represent data subjects, so without the need of a mandate. And it will be interesting to see how this will probably bring us to a mechanism of collective redress in the European Union for the right to privacy and data protection. And actually the impact of this new regulation can be already, it's quite clear already. In the last year, many NGOs were founded in the field of privacy. One of the most famous one is the one founded by Max Schrems, that became famous for the Facebook case, that is already trying to gather complaints from individuals that will then be brought in front of courts. So in conclusion, both me and Mario, we presented cases in environmental and privacy matters that clearly show how the Court of Justice takes different approaches when NGOs try to access justice at EU level or at national level. We argue in our paper that access to justice for NGOs should be considered as a tool of democracy, of supranational democracy, as it's also established in the Aarhus Convention. We know that NGOs still have the possibility to rely on the preliminary rulings when they want to challenge EU legislation. However, we argue that this is not enough for three main reasons. The first one relates to the fact that preliminary rulings is subject to the discretion of national judges. The second one relates to the fact that not all EU legislation needs to be implemented into national law, so maybe sometimes NGOs will not have the chance to bring a case before a national court. And the last reason, which is actually one of the most important, it's because the European Union describes itself as a participatory democracy model. This means that everyone's voice should be heard during the decision-making process. However, we all know that this is not an easy task when big multinational companies and corporations have much more resources to lobby for their own interests at EU level during the decision-making process. So what we try to argue is that this can be, the strong power of these multinational companies can be counterbalanced by allowing NGOs to access justice at EU level and at least try to challenge, directly challenge EU legislation. We know that hoping for an amendment of the Treaty of the European Union is an utopia, and that it will likely not happen in the near future. That's why we argue for the Court of Justice to reconsider the Plowman test and to reconsider the strict approach behind it and develop an approach that is more inclusive and allows civil society organizations and individuals to challenge EU act before the court. And thanks for your attention.
Thank you to Diletta De Cicco and Mario Pagano. And now, without wasting time, I give the floor to Bernadette Greco of EURES Provincia di Lecce. EURES is European Employment Services, and she works in the Labour Department of the Provincia di Lecce.
So thanks, first of all, and I am Bernadette Greco. I work in this organization, and I am here. I am here just because went on the social media, I saw this event, and I asked Susanna Cafaro, whom I really thank, together with Saverio Di Benedetto, if this was a good occasion, an opportunity to present a project we are partnering as EURES within this organization, the organization hosting you. So this project is, the name of the project is European Solidarity Corps, and I just want to stress and highlight the importance of these two words in my presentation, although I will be very, very, very quick because we have run out of time. Solidarity and environment protection. As you might know, after with the Brexit result, there was really a tentative made by the EU member states reunited and gathered in Bratislava to fix the so-called Bratislava roadmap and to set some objectives and deliverables in order to make Europe more united and to give strength and to give a new spirit to Europe as such. So the idea of the European Solidarity Corps was really set in this occasion during the Bratislava roadmap and was announced by Jean-Claude Juncker in the State of Union speech made in December 2016, where he said, "I don't like Europe Europe of bureaucracy. In Europe, solidarity is the glue that sticks, and I want to do something for the European youth. So this project aims at boosting opportunities for young people in the field of solidarity. So I thought it was an occasion to present this project because of the graduates of university students who might be here attending this seminar, and even for the other side, in the sense that we need, in order to have successful matches within the project, both job seekers and employers. So, sorry, I'm not just running the slides. Da quale parte? Così. Da qui. So I just made some pictures of the people who have already benefited from this project, both incoming and outgoing. Incoming means that these are people coming from Italy. This girl is from Lecce, actually, and this picture is of a French girl who came to have a solidarity activity in Reggio Calabria. And this is just the image of a DG, of a European Commissioner, because this project, as Europe is quite complicated in the sense that it was born under the aegis of 3 different DGs. So you can imagine how complicated it has been for us at the beginning, and for the public as well, I guess. So this is the legislative path of the project, and I just try to highlight how it was born and conceived. After the Bratislava roadmap and the speech made by Jean-Claude Juncker, we had the proposal for regulation for this European Solidarity Corps, and now, after the proposal for regulation made by the Commission and amendments made by the European Parliament, we are just waiting. It's just a question of a couple of weeks for the new regulation. It's important for you to know that within this project there are 2 main strands, the volunteering strand and the occupational strand. And we deal with the occupational strand because we want to provide paid traineeships, and I really want to underline this word because I know that there are plenty of unpaid traineeships around the world, even within the UN system, and job offers, giving the opportunity to youth to improve their skills and to become more employable. This is just a picture with reference to the legislative path of this regulation. So the European Commission made a call, we submitted the proposal, and the proposal was successful, and the project is, the lead partner is the EURES National Coordinating Office, which is in the former Ministry of Labour, which is now called ANPAL, acronym of Agenzia Nazionale Politiche Attive per il Lavoro. So it's an ongoing project. It will end in one year's time, and it tries to, as you see, there are two main parts: job demand and job offers. So it addresses youth aged between 18 and 30. They must be EU nationals, and they must be legally resident in one of the EU member states. On the other side, we must and we search for employers who have job vacancies and traineeships in the solidarity sector. And the innovative feature of this project is that it includes NGOs, associations, consortium, companies, small, medium enterprises, no matter the legal status of these companies. All employers as well as job seekers can access the financial benefits which are behind this project. And let me just now tell you which the financial benefits are. First of all, it's better first to say that within this European Solidarity Corps there are 6 main sectors, because one might think just of education, of social activities, but within the European Solidarity sectors, even environment protection is seen as a solidarity activity. So this is why my wish and my call to action is for all the employers and NGOs active in this field, just try to use this tool, because it gives financial help both to the people you are recruiting and both to you as employers. There are 2 main databases. This one is for the job seekers and is on the European Youth Portal, where you have to register. And then this one is for employers, and it's on ANPAL website. which are why this project is so attractive. Let's say that it gives financial support for traineeship once they are done, or even for job offers. For example, a person aged from 18 to 30, an Italian person holding Italian nationality, willing to do an internship, a paid traineeship in another EU member states in one of the sectors I mentioned to you. So this means that you are given support and free access to this project. The US office makes the pre-selection recruitment and gives as well other services which are gathered within the placement, the post-service or placement services. And financial benefits, which I will show you. To the employers, the same, in the sense that the employers can address us and we will take care of his vacancy, filling in this vacancy, searching for the right candidate. And since we have access to this European database, you can imagine that we can find the mostly highly skilled candidates, because there are really people from all over Europe with all the imaginable skills. And they have access as well to the financial benefits. Now let me just show you the financial benefits. So these are for the job seekers. So you are entitled to have some financial allowance if your employer calls you for an interview. You are entitled to relocation allowance. For example, if you move from Italy to France, to Belgium, to another EU member state. You can have as well a top-up fee for your traineeship, because most traineeships are not paid, or if they're paid, you cannot face the cost of living in another European country, and you can even ask for money to attend a language course, and the return ticket after your experience. For employers, they have the so-called integration program, which is just a lump sum given to the employer in order for him to set up a real integration program for the intern, in the sense that thanks to this experience, the intern will acquire more skills and become more employable, because we must not forget that this initiative was born within the European initiative called the New Boost to Youth Growth and Labour. And if you need more information, I was really too quick, you can just find here the addresses, the mail, and you can just refer to myself to have more information for this.
Thank you. Thank you to Benedict Greco, just to respect time. In particular, thank you so much. Now it's the turn of Federico Bonomi from University of Pavia. He's going to speak about European instruments for environmental policy and resources for supranational democracy. Please.
Thank you very much, Professor. It's a really great honor for me that I'm still undergraduate to speak here in front of you. Since we are running out of time, I will be very hurried. So, in my analysis, I will analyze the problem of environmental protection, in particular the carbon emissions, starting with the instrument, the analytical tools of public economics. It's an important discipline to study environmental issues, and I start with a critic of what Professor Masini stated in his intervention, because in an idealistic world, public goods are underdimensioned, but in this real world, public goods still exist because states still exist, and they have a very important power over regulation and coercive power. So we have a definition of public good, a good that is not rival and not excludable, and the emission, a carbon emission and cleaner is surely an example of public good, and a public good has particular features such as individuals have no interest in stating their marginal evaluations of the value of those goods, so they act as free riders. And then we have negative externalities, because they don't enter in the count of cost and benefit for economic decisions. So this is a case in which public intervention is required to avoid a market failure and to prevent a lot of negative outputs. So we have two questions. We need public intervention, but public at which level and with which instruments? Let's start from the second question. Which instruments? We have different kind of public approaches to tackle environmental issue. In particular, we have regulation that is used by the EU for car emissions in particular, but we have also only a theoretic approach, that is the allocation of property rights through the cause theorem. But this is in the real world a failure, because there are some case studies of this approach that state that is a failure. And then quite basically, and then we have two main instruments that are Pigovian taxes in the form of carbon pricing through international agreements, and then emission trading systems, one of which is being developed by European Union. Then the first one, we have a lot of examples of failed international agreements, in particular the Kyoto Conference, because they were based on pledge and review mechanisms. In fact, countries made promises, I will cut these emissions, and then other countries only the power to blame them. So with the game theory tool, we can state that the dominant strategy, the equilibrium of the Nash equilibrium, is not the best one solution, because there will be a decrease of commitment by countries. But there was a recent proposal by the Carbon Pricing Project, led by important economists such as Stiglitz, which proposed to another action that is called common commitment, in which the gaining of this effort is distributed by the minor amount of countries. I invite you to read my paper that I prepared. The tables, they are very clear, and in this situation we have no Nash equilibrium but multiple equilibriums. So while states can contract to have the best solutions. So this kind of instrument does not foresee supranational democracy, because states can actually have successful contracts and conferences. And then we have the other instrument I mentioned, that is emission trading systems. With the emission trading systems, the state or the institution, the supranational institution, gives imprenditorial activities the right to emit carbon. So in the first step, this is the example of the European Union, the state gives for free some allowances, and in a second moment it makes auctionings, so the institution can achieve some funding. Which is the problem with the European case? The first one is that a supranational democracy and a democratic accountability is not strictly required, because also a technical authority can have this role. And the second problem is that national states obtain these grants, so there is not a European own resource from this activity, but states obtain this fund and they spend it for national projects, environmental projects, but still national projects. So this is a critique of functionalist approach, because some scholars expect to have a magic situation in which we have a problem, we need a common solution, then with a magic the problem is solved in a supranational democracy. This is not true, because to create a supranational democracy is needed a political will, and this is particularly important, because environment is a quite complicated matter, and carbon taxing is just one of the approaches, and we need so an organic solution, and then an organic solution for supranational democracy. So we have to look at organic proposals, and still considering a realistic approach. Institutional realistic approach, looking at the head of governments, there is just one leader that is currently proposing an increase of European integration, that is Emmanuel Macron. In fact, he proposed just for environment the adoption of green dumping, so we can tax products coming from countries that have a lot of emissions. This is quite realistic because Germany would never accept it, because it has a lot of economic benefits with carbon-dependent countries. But starting with the Macron proposal, we can support a vision of a Eurozone in particular, with provided with own resources to finance, for example, investments to help the solution of environmental problems. So I was very hurry. I invite you to read the paper if you are interested, and thank you for your attention.
Thank you, dear Federico. You should be aware that Professor Massini is going to write your name in his little black book. All right, so last one, Audric Alexander is going to speak about the PACE, a European transnational party. Please.
Per iniziare vorrei ringraziare all'Università del Salento, a Susanna e a tutti coloro che hanno partecipato all'organizzazione di questo. Un grazie particolare ai traduttori che permettono all'italiano di esistere in queste discussioni. Ieri abbiamo cominciato tutto questo convegno sognando di democrazia supranazionale, e Susanna ci ha parlato di inclusione, e poi dopo Susanna tutti hanno parlato di inclusione. Ma se vogliamo davvero che i cittadini siano coinvolti in una democrazia sovranazionale, che sia europea, mondiale, la prima condizione è che essi comprendano, che capiscano le poste in gioco, i dibattiti, le nuove proposte, perché se i cittadini non riescono a comprendere, allora non faranno altro che allontanarsi o distruggere il progetto, la democrazia sopranazionale, questa democrazia. Oggi nell'Unione Europea è di moda fare conferenze di alto livello usando solo l'inglese, senza proporre nemmeno la traduzione del paese dove siamo. Credo che se vogliamo includere, si può fare un po' meglio che solo l'inglese.
Ci ho provato,
Questo
He tried it.
I
Ci
tried.
ha provato.
questo convegno con la traduzione è la prova che si può fare, quindi grazie. Vi immaginate un convegno internazionale negli Stati Uniti in cinese senza traduzione? Non si può, credo.
Poco, esatto.
Pace, il Partito dei Cittadini Europei, the Party of the Citizens of Europe, Partitul Cetățenilor Europeni. Pace vede nel multilinguismo la prima occasione di essere un laboratorio. Sperimentiamo un funzionamento quanto più multilingue possibile, ci proviamo, ci sforziamo e ci miglioriamo ogni volta di più, sempre di più. ecco il nostro laboratorio sperimentale della vita politica europea, PACE, si dice PACE in inglese anche, in tutte le lingue. È un partito europeo creato nel 2007 in Bruxelles, direttamente a livello europeo, sotto forma di Associazione Internazionale di Diritto Belga, AISBL. Europeo quindi non solo nell'ideologia ma anche nella struttura, nel funzionamento e nell'origine dei suoi membri. Sì. Perché hanno creato PACE? Hanno creato PACE perché l'idea è semplice: se vogliamo avere una unità politica europea, i cittadini devono appropriarsi il progetto, la costruzione dell'edificio, altrimenti lo vedranno come un corpo estraneo da combattere. E dato che si parla di progetto europeo e non di un progetto nazionale, bisogna coinvolgere i cittadini europei. L'idea per me sembra ovvia. Ancora non si può immaginare negli Stati Uniti partiti differenti in ogni Stato, non immagino, ma non è tanto ovvio perché se vediamo a Europa, in Belgio non ci sono nemmeno partiti nazionali, sono regionali, anche nella Germania hanno partiti regionali, Baviera. La vocazione di PACE è identificare e difendere l'interesse comune europeo, partecipando alle elezioni con un programma europeo da membri di diverse nazionalità. A giugno 2017 abbiamo partecipato alle legislative francesi, era la prima volta, e per le elezioni europee del giugno 2019 presenteremo i nostri candidati in 4 paesi, qui nella regione, nella circoscrizione meridionale per l'Italia, con la nostra candidata Maria Pia. Noi continuiamo a sperimentare in modo serio e costruttivo anche a livello amministrativo, perché il diritto europeo, i diritti nazionali non conoscono i partiti europei, non esistono. Quindi ci sviluppiamo in un voto giuridico e così causa molte preoccupazioni, per esempio dalle donazioni al finanziamento. È molto difficile lavorare con un voto giuridico perché, per esempio, se rispettiamo la legge francese, la legge spagnola sul finanziamento, violiamo la legge belga, quindi è molto complicato. Ma sperimentiamo, proviamo. Per le elezioni europee faremo campagna di modo diverso. Supporteremo il sistema dello Spitzenkandidat, il sistema che è stato sperimentato 4 anni fa nelle elezioni europee del 2014 per prima volta, che permette ai gruppi di partiti europei avere un candidato per la presidenza della Commissione europea. Supporteremo questo sistema perché crediamo che con questo sistema l'Europa è passata da un sistema di democrazia papale a un sistema di democrazia parlamentaria, e per questo è molto importante. Concludo ricordando che l'Europa è un laboratorio della vita democratica sovranazionale ovunque nel mondo. L'Europa è un esempio da guardare e imitare. Il progetto europeo non può e non deve crollare, invece deve proporre nuove idee. Forse i partiti europei sono una nuova idea che possiamo proporre. Grazie.
First of all, I would like to thank University of Salento and Susanna and everybody who was involved in the organization of this event. I also would like to thank the translators for allowing all this event to take place and these discussions. Because what I think is very important, and there was something that Susanna started the discussion, the debate with, was inclusion. So to have inclusion in the process, we need to allow all this. So what I would like to say is that we in our party, which is called PACE, the Party of European Citizens, we give great value to multilingualism because we think that this should be appreciated a lot, especially if we talk about a multicultural environment. We need to imagine that in order to have political union in Europe and in the world, we need to consider that the citizens are the first point of reference, and their languages are also important. We can't think of an event taking place in one country, for example in the US, that is held in Chinese without translation. So again, we thank you for arranging this and making this possible. I also would like to talk about our party, which is a different party from what has been done so far, because we are a party for Europe. So it's not a party that represents regions, that represents nations, but it's a party that represents Europe. And it might sound obvious, all this, but in reality, it is not, because we have countries in Europe where there are regional parties as well. So that's something that we need to overcome. We need to think in a way that we consider European parties. And this is our mission in PACE, in our party. We are always experimenting, because one of the issues that we are facing is that there are no regulations in terms of this. Because, for example, we can abide by the Spanish legislation, the French legislation, but we might be violating the Belgian legislation, especially when I'm talking about funding and donations that we can receive as a party. So again, we have already taken part in the elections in 2017, and we will campaign again in 2018. And that is going to be our mission. So coming with a single party for Europe, and we will have a representative in this area in southern Europe, with one of our candidates, who's called Maria Pia. So again, we will try to experiment. We will try to find we will try to do all we can to make this possible. And I would like to conclude that Europe is a laboratory for supranational democracy, and that's what we will have to try to do, either here in Europe and all over the world. So it's not just it's not just a project for EU, but it's a project for the all that can be taken at global level. It's a project that can't and must not collapse. So we really need to make whatever we can to build it. And I would like to thank everyone for listening.